Peace, Prince L, Moor's Temple of Light, Trust Core, Allah, Father of Love, True Peace, Freedom, and Justice. Allah is my guide and my salvation by night and by day through His Holy Prophet, Noble Ali. Amen. Good evening, ladies and gentlemen. You see the time on deck. I just got to show you this information real quick. This is being presented and provided for informational and educational purposes only. I strongly suggest that if anyone is seeking any type of information, be advised to do your own research before seeking any other consult with any other individual or any corporate representative. Tonight, information regarding Joinder and Severance regarding a criminal justice matter. Alright? Now, understanding what an accusatory instrument is, it is a written statement which accuses one or more persons of the commission of one or more offenses and which is sufficient to support a prosecution. Related offenses, two or more offenses, are related offenses if they are based upon the same conduct upon a single criminal episode or upon a common plan. Alright? So when an individual is being presented as a co-defendant along with another party, right? They are being joined within one accusatory instrument unless there are unrelated offenses, which are not related offenses. Joinder are any two or more offenses committed by the same defendant, alright, may be joined in one accusatory instrument in which of each offense stated in a separate count, or may be joined for trial upon the application of the prosecuting attorney or the defense. So, B, looking at 13-2.1, Joinder offenses, section B, may be joined for trial upon the application of the prosecuting attorney or the defense. Now, if it's two adults, they may be joined by the prosecuting attorney. Basically, the prosecuting attorney is going to say that both parties are joint in the offense, that they're guilty not just by association but in action. Alright? Standard 13-2.2, Joinder of defendants. Two or more defendants may be joined in one accusatory instrument, I, charging one offense or charging two or more unrelated offenses, right? Or two, charging two or more offenses when the offenses are alleged to be related. Now, they may be alleged to be related considering that the defendants have not stated whether or not they were both in cahoots. Alright? Now, B, two or more defendants may be joined for trial upon the application of the prosecuting attorney or the defense whenever the defendants could have been joined in an accusatory instrument pursuant to paragraph A. Okay, now what that sounds like is if it's in the interest of the defendants to join their case in order to receive a reduced punishment, then they might consider doing that, right? Regardless of whatever action it is that they did or did not do. But if they did not do something, then there's a discrepancy there. Alright? Now, failure to join certain offenses. When a defendant has been charged with two or more related offenses which are within the jurisdiction of the court, a timely defense motion to join the offenses for trial should be granted. See? The defense motion should be granted unless the court determines that because the prosecuting attorney does not have sufficient evidence to warrant trying some of the offenses at that time, or for some other reason, the ends of justice would be defeated if the motion were granted in whole or in part. Meaning the court is not going to go through with it if they feel that there is not enough evidence, not enough sufficient evidence to warrant trying the offenses at that same time. Section B states a defendant's failure to move for joinder constitutes a waiver of any right of joinder as to same conduct or single criminal episode, offenses which the defendant knew had been charged. Okay, see, so it's the defendant's duty and responsibility to state that they did or did not commit the action. If they fail to state that they did not, it is basically them agreeing by acquiescence through silence that they did commit an offense of the same conduct or of the same or of a single criminal episode. Section C states a defendant has been tried for one offense may thereafter move to dismiss any additional offense based upon the same conduct or the same criminal episode unless a motion for joinder or of these offenses was previously denied. Alright, so we got through the basic parts of that, alright? And before we even continue with severance, let's just look at section D real quick. Entry of a plea of guilty or nolo contendere to one offense does not bar the subsequent prosecution of any additional offense based upon the same conduct or the same criminal episode. A defendant may enter a plea of guilty or nolo contendere on the basis of a plea agreement in which the prosecuting attorney agreed to seek dismissal, agreed not to oppose dismissal, or agreed not to initiate prosecution of another offense based on upon the same conduct or upon the same criminal episode. Alright, so here it is that the prosecuting attorney can agree to seek a dismissal, right, for a joinder if not opposed, or if it is not agreed to initiate prosecution of other offenses based upon the same conduct or upon the same criminal episode. Alright, so the prosecuting attorney may agree with the defendant's attorney, or the defendant if the defendant is indeed representing himself in pro se or in propria persona, depending on whatever state or state jurisdiction it is being seen in, unless the individual is dealing with a case that is in controversy over the amount of $75,000, it's going to end up being in a state court. At the highest level, the state Supreme Court is considered the state's appellate court. So you want to get into the federal venue you're only going to be able to get into the federal venue if it's a matter over $75,000, because that exceeds the state and local municipalities statute or scope of subject matter jurisdiction and personal matter jurisdiction if there's a corporation involved. But that's another video. Severance of offense. Whenever two or more unrelated offenses have been joined for trial, the prosecuting attorney or the defendant shall have a right to a severance of the offenses. Section B, the court on the application of either the prosecuting attorney or the defendant should grant a severance of related offenses, before trial whenever severance is deemed appropriate to promote a fair determination of the defendant's guilt or innocence of each offense, or Section II, during trial whenever upon the consent of the defendant or upon a finding of manifest necessity, severance is deemed necessary to achieve a fair determination of the defendant's guilt or innocence of each offense. Section C, when evaluating whether a severance is appropriate to promote or necessary to achieve a fair determination of the defendant's guilt or innocence for each offense, the court should consider, among other factors, extenuating circumstances, in view of the number of offenses charged and the complexity of the evidence to be offered. The trier of the fact will be able to distinguish the evidence and apply the law intelligently as to each offense. Severance of defendants. I'm going to leave the rest of that information for you to go ahead and just review, but it can be done at a trial at which the statement is not admitted into evidence, a joint trial at which the statement is admitted into evidence only after references to the moving defendant has been deleted, provided that, as deleted, the statement will not prejudice the moving defendant, or severance of the moving defendant. Alright? So, timeliness of motion. A defendant's motion for severance of offenses or defendants must be made before trial. So here it is that if you have not made it to trial and you're still basically in a pre-trial aversion, alright, So this is like basically an informal hearing, which is not a court of record. So anything that is being said in this court is not official. Not even the hearing officer is a judge. It's more than likely a judge's assistant. All right, and they're just making a determination as to whether or not it is worth the court's time to hear the matter. But if they cannot settle the issue in a pretrial aversion, they'll keep making forms of continuances until the case can be heard before it goes to trial. So here it is that if an individual is a defendant or a co-defendant and they are not an associated party or a party of guilt or an individual involved in a single criminal episode, then a motion for severance should be sought by the moving defendant, basically by the individual whose guilt is at stake, or whose, rather, excuse me, my apologies, whose innocence is at stake. All right? So, if you have any questions, comments, concerns, please feel free to put those in the comment box below, or feel free to email me at moorstemploiht@gmail.com and rewind that as many times as you need in order to hear this information as clearly as you possibly can. Or do your own research and go to Joinder and Severance Criminal Justice section, www.americanbar.org /publications/criminal justice, criminal_justice_. All right, so enjoy that, ladies and gentlemen. And if you can't find that, just be sure to do a little Google foo. What is a motion to sever defendants? All right, usually a motion to sever is made by either the state or the defendant in order to ask the court to have separate jury trials on the different charges. Most times it is the defendant who asks for severance so that your jury won't hear all the evidence about the charges in the same trial. We're just using their information against them, ladies and gentlemen, not consenting to any of their fraudulent or colorable accusations or allegations. We're correcting the fraud, all right? Refuting and objecting all inaccurate, unverifiable, unvalidated charges and